Luke Busby, bar number 10319, appearing for our Nevada judges.
Good morning. This is the time set for case G24M, and I apologize, I'm a little bit behind this morning, but let's see. We have some in person and some here. So I'll start with who's in person. Mr. Naimi, would you like to make your appearance?
Yes, good morning, Your Honor. Jason Naimi, bar number 9441, on behalf of who are present on Zoom.
Good morning, Marina Dalia-Hunt, bar number 15367C, on behalf of the protected minor.
All right, then we have Ms. Dwiggins. You want to start with your appearance, please?
Yes, good morning, Your Honor. Dana Dwiggins appearing on behalf of.
And then we have Ms. Deeter.
Good morning, Laura Deeter, 10562 on behalf of.
And then lastly, it looks like we have Mr. Busby. Is that how you say it?
Correct, Your Honor. Luke Busby, bar number 10319, appearing for our Nevada judges.
All right, so I've reviewed everything.
Good morning, Your Honor. My apologies. Also, Amanda Connor, bar number 12193 on behalf of the as well.
Okay, thank you. Sorry. All right. In this case, guardianships are not sealed by any statute. And this case specifically is not sealed. So, and there has been already a lot of media attention in this case. And Mr. and Mrs. have already done a previous press conference. So I don't think that they're concerned about their names and faces being in the media. And in this case, media coverage is a horse that's already out of the barn here, because it's already been happening in this case and the related case. And as I read the Falcone case, there's a balance in each individual cases with the presumption that court hearings and trials are open to the public, with the specific safety and privacy concerns that may be in a case. In this case, the facts are very tragic, and there might be some safety concerns and valid privacy concerns. That's why the court entered an order sealing the petitioners and family members' addresses. But this case, I think I have to allow media access with the same limitations I've done in my custody cases. And Mr. Falcone is familiar with that. I make the order very specific so everybody's on the same page that there's no live streaming of the proceedings. And as is practice, as I understand it, he redacts the names and faces of the parties and witnesses. And then we just need to be careful of not mentioning any home addresses. In this case, because the nature is we have 3 competing petitions for guardianship of this protected minor, there may be discussions of what kind of housing each petitioner has, but we don't need to put their specific addresses. Obviously, that it would be a safety concern, is knowledge of anybody's addresses and privacy there. With that, Mr. Busby, do you think your client? I don't think your client will have any issues with those, but
I don't believe so, Judge. I think he's familiar with this court's practice and this and other related cases. And I think the court is adequately addressing the presumption of openness under SCR 230 and under the Falcone decision, and that in order for closure to occur, a compelling interest has to be forwarded, and closure must be narrowly tailored, no broader than necessary to protect that compelling interest. And there has to be, reasonable alternatives, and you have to make findings adequate to support the closure. And there's nothing in the record that we see in this matter that would support that at all. So we think the court's approach is consistent with SCR 230 and Falcone.
okay. So the only people whose faces and names will be there would be the attorneys and the court.
May I just briefly make a record? I understand the court's position, but
I would also like to make a record, but please go ahead.
Thank you. Just on behalf of the child, of course, this matter is extraordinarily different from a standard custody case, which is, of course, what was under consideration in Falcone. This is a baby who lost both parents in a mass shooting. She is 7 months old. She will never know her parents. And as the oppositions very clearly stated, this will be the information that is available on the internet. There is a large difference that I believe amounts to extraordinary circumstances under the sealing statute and rules from written pleadings and orders and YouTube videos where anyone can comment about the nature of the shooting that amount to extraordinary circumstances that are completely different from a standard custody case. I believe the Falcone decision, I'm sure counsel is intimately familiar with Falcone, but I believe that it also cautioned not treating every single family law matter the same. Guardianship by its nature is different than custody. In custody, children will end up with one or the other parent. Here we have an orphaned child who is now going to be subject to a three-way litigation where everything about what has gone wrong in this family will now be on the internet. I respect the court's order. I understand the court's position, but just on behalf of, I object to this being broadcast.
I think that was very aptly put, and I simply will just emphasize and reiterate what she said. But in addition to that, if we're to look at the test under Supreme Court Rule 230, nothing here that we have requested or objected to is in any way seeking the limits sought here aren't suppressing the public's right to information. They are still going to have the same access to pleadings and whatnot. Nothing in addition can be ascertained by having in-camera appearance. Okay. However, the damage and potential harm to an infant who right now can't stand up for herself, and the social media videos, comments, and whatnot that might then at some point be shown to her, where it's her family members and loved ones litigating one another over this. If no one can appreciate the level of potential harm to that, then I don't have words for the court. The public's right here is not, their oversight is still intact. And so having the in-camera doesn't do anything there's no additional benefit for that. Other than, I guess, they're looking for social media clicks.
Ms. Dwiggins, Ms. Deeter, either one of you want to?
Yes, Your Honor, I just want to join in and parallel the comments that were mentioned by both counsel. Obviously, my clients did do a press conference as it related to their fight with, and as you can imagine, the emotions were very high. They have kept everything in relation to this guardianship proceeding silent, and we just parallel those same concerns.
And similar to other counsel, Your Honor, the extraordinary circumstances which make this an issue of interest to the public are the same extraordinary circumstances that raise the issue as to why this should not be broadcasted. This is certainly a very tragic event. And it's not just the risk to the difference between, the RJ doing a media request or KTNB has done media requests in the other cases is you're going to have snippets on the 5 o'clock news. You're going to have reporting, which will exist forever. But that's different than how our Nevada judges typically operates as far as posting the entirety of the proceedings on YouTube, which will also then live forever. It's a different level of access to the court proceedings. And you have other children as well. The court's well aware of, and it's not just the risk to, if this is broadcasted to be on the internet forever. You also have older children who have friends who are nearly teenagers who have the possibility of having open, unfettered access to all of this, which raises harm to those children as well. And I do believe there are extraordinary circumstances. I appreciate that the court is trying to narrowly tailor those, but my objection is more focused on the entirety of the proceedings being broadcast to YouTube, even if it's not live streamed, because that will exist forever for all of these children to potentially view in the future.
All right, I think we're down to you, Mr. Busby. Would you like to make any other record before I respond?
Your Honor, just briefly in reply, there's a presumption of openness under the law itself. This isn't just the position of Mr. Falcone. This is the position of the Nevada Supreme Court and its rules and in the Falcone decision. There's been no showing of an impact of coverage on the right to any party to a fair trial, the impact of coverage on right to privacy. That's usually something like medical records, something to which you have a privacy right under law. There's no issue of safety and well-being of any party going forward. There's no distraction from the participants or detraction from the dignity. Mr. Falcone does what he does in a very professional manner, and he does so in accordance with any restrictions that the court should put forward. There's no question of adequacy or interference as well. Now, the public has a strong right to know what happens in its courts. And that's really what the Falcone decision relied upon, is that physical access to courts is guaranteed under the Constitution, under the First Amendment, as part of the freedom of the press. And electronic coverage is just an extension of that that's been codified by our court in Supreme Court Rule 230. Now, in weighing the factors, there's been, the things that have been expressed here can be expressed in basically any kind of family law, any kind of controversial family law proceeding. And the court in Falcone was very clear that generic privacy concerns in family law cases are not sufficient to overcome the public's right to access without extraordinary circumstances. And I've heard extraordinary circumstances, that word used a few times, but it's not clear exactly what those are. In this case, the facts are extraordinary, of course. Murder of this poor child's parents is terrible, but that in and of itself, does not justify complete closure of the proceeding to override the First Amendment issues, which are incredibly important. And the public has the right to know what's going on in the proceeding, but it also has the right to be educated about how these proceedings work. Further, there's 3 other cases that are related to this: 2 custody proceedings and a divorce proceeding. And I believe camera access has already been permitted in those proceedings. So closing down access to this case isn't going to achieve the results sought. I'm glad to answer any questions the court may have.
All right. As a long-term family law practitioner and a family court judge, my personal opinion may be different, but the Supreme Court disagrees with all of us. So I have to follow what the Supreme Court says, and they've been very clear, including summary denial of I think there was more than one petition for rehearing in the Falcone case, and they've been very specific. In this case, if I say no to camera access, all that's going to happen is Mr. Falcone is going to go over and get the trial tape, and he's going to post it, and it won't be what is it called, Mr. Busby? High definition. It'll be just that he can go get the jazz tape and publish that online. And there's nothing, in this case, A, nobody's requested sealing. B, it probably would not qualify for sealing, because all that this trial is really going to be about is which placement is better for, and then some of it, which person is better, which may be different, which person is better to marshal the financial claims and the financial assets and stuff. So the issues in this case are less controversial, less emotionally impactful than it's going to be in the custody case regarding the children. And those orders were already made before the custody case was assigned to me, that those cases are also open to media access. So with the limitations that there are privacy issues and concerns, and I understand that nobody really wants to be on the news, or most people don't want to be on the news. They don't want their faces on the news. Most people definitely don't want their addresses out there. So we do have to protect the addresses of all the participants and the other relatives who may not be participating in the case, but they were entitled to notice. So I'm going to protect those. I'm going to protect the faces of the witnesses who testify. But with those limitations, I think I have to, under the Falcone case, grant camera access to the proceedings in this matter. Mr. Busby, if you can prepare a more specific order than that form order, and submit it with those limitations that we're definitely not going to live stream this. We're not going to show any of the witnesses who testify, any of their faces, and definitely no mention of
May I make an additional request? I know on YouTube, you can limit videos that you can block comments. I would ask that be indicated on this video, on the videos of this trial. If it's going to be posted to YouTube, that comments are not allowed. They can talk about it somewhere else, but not on the video itself.
Mr. Busby, what
We'd object to that. We'd object to that, Your Honor. Community engagement is an important part of what Mr. Falcone does. People are going to have opinions about what's happening in this case as well as the other related cases. I don't think the court. I'm not sure we're getting into a First Amendment question there about whether the court can limit the speech of third parties.
Well, it would be limited. It would be limiting the speech of. Excuse me. Sorry. It would be limiting the speech of ONJ, who's sought to intervene here, and they have a very active Facebook page. They can host a robust conversation there. My concern is when turns 12 or 13 and someone shows her this video, all of the nasty comments that are going to relate to this case because of the public's strong opinions are going to be right there for her to see.
And they're just same issues with it on all of the other media outlets. They post it to their web page as well. What they show on the nightly news may be very limited, but they have the videos there as well. I just don't think because of all the things that happened up to date, I don't think we can control this media interest and public interest on it. And I definitely can't prohibit the dialogue about it. So I'm going to deny that request. And I mean, it's not a matter of whether I like it or think it's in the best interest of the child at issue here. It's a matter of what the Nevada Supreme Court says I have to do. And that what they've interpreted the First Amendment and access to courts to mean. So that's going to be the ruling on that. When's our next hearing in this case?
Not till October.
August. We have
Oh,
August 20th hearing.
It's not on my calendar.
I guess that's the original citation date, right?
Yes. Okay. I don't think that's. Yeah, I think the next hearing date is in October.
And Your Honor, as a housekeeping matter, while we're here, I don't know if it makes sense. I think it's my citation as well as Ms. Dwiggins. If it doesn't make sense to just move those to the date of trial, unless
yes, it does, except for I think I would need to extend the temporary. When does the temporary currently expire on that August 20th date? Let me see.
I think it's the trial date.
It's the
Yeah, I
trial.
believe it was
You
a
moved
trial
it to
date.
my
Because-
recollection, Your Honor, is you moved it to the very end of trial.
Correct.
Okay. Let me, I'm trying to find that. Okay, thank you. All right, good. Then we don't need, unless somebody wants to, we don't need the August 20th hearing.
No.
So I'll just continue everything over to the trial dates we have in the evidentiary hearing on October 16th,
Calendar call on the 3rd.
16th, 23rd and 24th. I guess that's how we set it for
Yes,
3
I
days,
think
right?
that's what was
That's correct,
available.
yes.
Yeah, with the
Okay,
calendar call in early.
yes, and
October, yes.
okay, all right. All right, thank you all.
Thank you,
you.
Your Honor.
Thank you, Your Honor.
Thank you, Your Honor. We'll get the proposed order circulated shortly. Thank you.
Perfect, thank you.